6 North Halstead today, talking about civil rights and the rights of people in police custody at the beginning of an investigation, police investigation, and after arrest. Comparisons between our system and systems abroad. Brendan Shiller, civil rights attorney, recently returned from a trip to Europe and France and Britain, and looking at different ways and things, how things are handled in police stations here in Chicago. When you're arrested, what are the first things you should know, or things that you recommend you should be thinking about as a person who's been arrested and arrives at the police station?
There's three basic things you need to know to say, first off. First off, when you're approached, the first question is, am I free to go? Because oftentimes what happens is law enforcement just use their presence to make people think they aren't free to go and essentially get them to consent to searches or to answering questions without the people realizing that they're doing that. If an officer just approaches you and starts asking you questions and you're not under arrest and you start answering them, there's nothing wrong with that. So the first question you always ask is, are you free to go? The next question is, once you're clear you're not free to go and you're going to be arrested, the next thing you say is, I want my attorney. This is what people don't understand. The courts have ruled that you can say, I don't want to talk, I don't want to say anything, as much as you want, but that doesn't prevent a police officer from keep coming back and asking you questions. Okay. It's until you say, I want my attorney, that they have to stop asking you questions. So oftentimes what we see is in police station, a police officer will ask somebody a question. They know some of their rights. They say, I don't want to talk. Police officer will go, leave them alone for a couple hours. They'll come back and ask them again, I don't want to talk. Go, leave them alone, a couple hours, come back, ask them again. By this time, the guy gets up and starts talking. I want my attorney is the next thing you say. And then the last thing you say is, I'm not going to consent to anything. You don't consent to searches. You don't consent to seizures. You don't consent to talk.
Now, how do you avoid a presumption of guilt of some kind on the police officer's side when you instantly start to be defensive about your rights and say, hey, I don't consent to searches? Doesn't that imply that you're hiding something?
Probably to police officers it does, but thankfully under the law it doesn't. And these rights exist for a reason. And maybe you are hiding something, but you're probably not hiding what they're looking for, or maybe you just feel that you have the right to be free and to say and to enforce your rights. It doesn't really matter. In this culture, in this country, law enforcement is going to be suspicious of that. But in this country, under the law, as long as you continue to be steadfast in enforcing your own rights, eventually you should be, through the criminal justice system, vindicated.
Now, there are situations where there seems to be a little bit of gray area in terms of what we're talking about, and I've personally witnessed this firsthand. Certain holiday weekends and stuff, you're going down Western Avenue and they're curtailing everybody into that parking lot over there in front of the Marianos there. It's a checkpoint where they stop a major street and they're forcing people to pull over or asking questions. Or it's a seatbelt check, a safety check. What are the legalities of this kind of situation? And can you just say, I'd like to continue on my way and not be a part of it?
So there's been a lot of litigation on these checkpoints. Personally, I believe it's pretty clear that these violate the Fourth Amendment, but the rulings have not been as clear on that. They give some leeway. Truthfully, I think the best thing to always do in any situation is be courteous. You start off by being courteous with the officers, never having an attitude, because there's no reason for an attitude. And then, if it was me, what I would do is say, again, am I free to leave? And I wouldn't consent to any breathalyzers, any searches, anything like that. I would contend that I think you may end up being arrested if you don't, but you're on pretty safe ground.
That's kind of a thing where it's like, if you're going to express your legal rights, be prepared for a challenge. I mean, it's just you're not going to always just be able to walk away from the situation.
Just because you're right in court doesn't mean you're going to be right on the street. Right. So if you're courteous and you say, am I free to go? You don't consent to any searches. You don't consent to a breathalyzer. You don't answer any questions. They should let you go. There's a chance that they'll arrest you, but if they do, you should beat it in court. Is the answer, because there's no reasonable grounds under DUI law just to randomly stop people. And if there's no reasonable grounds under DUI law, you can't just have them do a breathalyzer for no reason. And if you refuse to answer questions, they can't use that as an inference against you. So I don't think the checkpoints are legitimate, but they're allowed to happen, but you still have every right that you would have in any other setting. And if you enforce every right, you shouldn't be arrested. Let me tell you, because you asked about police stations,
right.
There's something else that's happening that First Defense is working on, and actually my law firm's working on with them, that kind of parallels this police station question and whether or not you have representation at the police station. Under Illinois law, you have a right to make phone calls, multiple, in a reasonable period of time so that you can call an attorney, so that you can let your family know that you've been arrested, because we don't operate in Chile circa 1973. We don't have disappearing people. But under Chicago Police Department practice, oftentimes people are held for 8, 10, 12, 15 hours until they're released and never given a phone call. And, you know, there's often excuses, well, they're being processed, which I've seen processing. Processing takes all of 5 minutes, so that's nonsense. And so we're trying to figure, out a way under either Constitution or legislatively, First Defenses, and we're working with them to try to begin to ensure that within a couple hours, people do make their phone call. Because one of the
so
scariest
that's
things,
not a given. That's not a right. You don't have a right to a phone call.
You do, but it's not well enforced, and there's no constitutional right per se to a phone call.
Okay.
Although we're trying to figure out if there's an angle, because obviously, in order to have an attorney, if you have a constitutional right to an attorney, you need to be able to call the attorney. And if you're arrested without somebody seeing you, nobody will know you're arrested until you make a phone call. Okay. And oftentimes that's what happens. And you know, the police department plays this game with this double standard that there's some right to privacy, so they don't tell people if your family members call and say, "Are you arrested?" But they'll immediately release your mugshot to the Sun-Times or the Tribune so that they can plaster it.
Okay.
So they don't really believe in privacy, but they use it as a game to keep people from their loved ones, because that's how you, in their mind,
you put the pressure psychologically
the psychological pressure to maybe get a confession. The problem is any type of pressure, if it's going to result in a statement, as many times as not will result in a false statement.
Well, I tell you what, let's take another short break. When we come back, we'll have some closing thoughts. Stay tuned.